Good afternoon, members. We have already formed a quorum. It is also time to start, so I call the meeting to order. First of all, let's invite the administration to join us. We are waiting for the representatives from the government.
I would
like to thank the government officials for their attendance. Since we know each other, so I'm not going to introduce them one by one. On the 28th of October, we held our last meeting, and for the points raised at that meeting, the administration has come back with a written reply. You may want to refer to paper CB bracket 2 221/15 to 16 bracket 01. For the questions raised by members, the government has come back with a response. I suggest that we continue with the with the CSA proposals from the administration. When we come to the relevant clauses, then I think members may want to comment on the administration's reply. At our last meeting, well, in fact, we have completed our scrutiny of the CSA proposed by the administration to Clause 2 and Clause 4B. Mr. Wu Chi-wai told us at the last meeting that he would be moving amendments. I've just received the draft CSAs from Mr. Wu Chi-wai. Mr. Wu told me that in relation to Clause 4, Clause 5, and Clause 61, he's going to move an amendment. Of course, in his letter, Mr. Wu Chi-wai has requested that the Bills Committee should support him so that the CSAs will be moved by the Bills Committee. Mr. Wu, regarding your proposed CSAs, we were only given a very short notice, so I suggest the following. To enable members and our legal advisor to have time to digest the proposals regarding the draft CSAs. If the administration has got some initial replies, we want to hear them. And then Mr. Wu may want to brief members on his proposed CSAs. As to the next step, I think it's better for us to keep it for the next meeting. That is the 16th of November. We don't have to wait long. I think at our next meeting, we can have a more in-depth study of the CSAs to be proposed by the Deputy Chair, that is Mr. Butcher Wai. Would you agree with me? So, Mr. Wu, first of all, concerning your proposed CSAs, would you like to walk us through your proposals or supplement what you have already written? Thank you, Mr. Chairman. I have given you a paper and I've included the draft CSAs. I think it is self-explanatory. I think it echoes what has concerned me all the time, so I'm merely reducing it to writing. I would like members to have a look of the appendix to my paper. Your questions are welcome. At the same time, I want to say that the spirit of my CSAs is as follows. While we were looking at the various clauses of the bill, we understood that for the property management companies and the property management practitioners who are licensed, they need to follow the code of conduct, and that's the spirit behind my CSAs. Therefore, I'm saying that they should abide by CAP 344. They should also follow the DMC when they discharge the work, as well as guidelines deemed to be appropriate by the PMSA. Therefore, this is in line with what we have been discussing. But of course, there is one difference. The administration would like to include in the subsidiary legislation a requirement that they should abide by the DMC as well as CAP 344. That will be put in the beginning, and then for the defense mechanism or the disclaimer, it will also be provided for. I want to say that once the bill is enacted, the two most important Bibles for property management, that is the DMC as well as CAP 344, I want to be sure that compliance with the two documents should be highlighted in the principal ordinance so that the licensed PMCs, when faced with requests from owners' corporations that may not be in line with the BMO or the DMC, and this is not uncommon, the PMC can show a copy of the principal ordinance saying that this will be regarded as a disciplinary offense and it will be against the law. I think this will facilitate the work of building management so that we will give due respect to BMO as well as the DMC. Of course, I've made myself clear in saying that it is a duty to follow the requirements of our laws, but of course, while all laws are equally important, but then for these two documents, I think they are more sort of encountered in the work of the property management. Therefore, I think we need to have an effective way to make sure that the PMC and the PMP, as well as the owners' corporations, can understand this point clearly. That is, failure to meet the DMC or the BMO requirements, the licensees will be penalized. And then for clause 61, if it is alleged that there is a case of non-compliance, according to clause 61 as it is said that as long as you are acting in good faith, then you will have a defense. Now, I would like to replace it with the following terms, that is, taking all reasonable steps and exercising all due diligence. In other words, it is a higher threshold than in good faith, and I think such a defense mechanism can be found in other pieces of legislation, like the Building Energy Efficiency Ordinance, as well as Safety of Products Ordinance. So I hope members will consider my CSAs and see if you have any questions. I'll be happy to take them. Thank you. Mr. Kwok from the administration, do you have anything in reply? That is for his paper as well as his verbal supplement. Mr. Kwok. Well, it was only this morning that we received the proposals from Mr. Wu, so we need time to study the matter further to find out about the effectiveness of the CSAs. But let me share with you my initial comment for the proposed amendment to clause 4. As I have pointed out last time, and Mr. Wu has also said, that all laws are equally important. It is not that one piece of legislation is more important than the other. By highlighting BMO Cap 344, does it mean that the managers don't have to meet the requirements in other legislation? And then for BMO, it is more about regulating the owners' corporations rather than the property management companies. So I just wonder whether it will be effective in achieving the objective, that is preventing the PMCs from doing anything that is not in compliance with the DMC or the BMO when requested by the owners' corporations.
I think that merits some more study. Now, as for clause 5, there can be codes of conduct, especially for A1. The suggestion is that there can be, where there are contravention of Cap 344 or DMC for the license holder, there can be certain codes of conduct meted out. Because for Cap 344, the jurisdiction and is under the Lands Tribunal. And I do not know whether this code of conduct can be issued. I do not know whether it would contravene Cap 344 given its purview under the Lands Tribunal. So I will have to look into this with the lawyers. All right, Mr. Wu. Concerning Mr. Wu's proposed amendments, are there any other views, perhaps preliminary from members? There is none. As mentioned earlier, we all need time to study the amendment proposal, and I would like to see the administration on the basis of Mr. Wu Chi-wai's amendment proposal to spend some time studying it, and after the meeting to come back with written response for the perusal of members. As for the next meeting, it will be on the 16th of the month. and if possible, provide that response before then. And after that, we will have another meeting on the 30th of November. So let us deal with that in this manner. Wu Chi-wai, just 2 small points to supplement. I would like to draw everybody's attention to clauses 4 and 5 amendments. They will have to go hand in hand. And I have also specified this in my document. That is to say, if we agree to clause 4, then it will have to go hand in hand with clause 5 as well. The 2 will have to be accepted at the same time. And that's the proposed amendment. The other is to make it outstanding from the ordinance, the management ordinance itself. Well, I would also want to highlight that, in fact, the practitioners, the PMPs, are also, it's also applicable to them. That is to say, these licensees, the individuals, as well as the companies, the PMCs do also come under the reference here. I would want to highlight that. And another point, which the administration had not responded to, basically that there will be codes of conduct and there will be guidelines for the PMPs and PMCs. I would like to know, in the past, the presentation had been that the code of conduct that's going to be issued by the supervisory body, there will be this kind of content. I just want to say that I have not exceeded the terms therein. All right? Well, we have gone through some of the amendments as raised by the government in clause 2, and perhaps members can, on the basis of the proposed amendments as raised by the government, CB 232 Annex B, if we can continue with those proposed amendments, and we go to clause 4 now. That is to say, we have already gone through clause 2. And as we know, Mr. Wu, the Vice Chairman, has certain proposed amendments to this. And Mr. Kwok, I would like to know whether you have any other supplements to make apart from the ones you have made just now. No? All right, members, anybody who has further amendments or further opinions to express concerning this? No? In that case, we go to clause 5. Mr. Kwok. For clause 5, it is 5.1, and basically it is to extend the terms of reference, and that is to say there can be a code issuable, and that is for any decision by the and this is extending the terms of the of this clause. I would like to know whether the expanding the scope of the clause so that non-compliance with the notice given under clause 21(2) and non-compliance with summons would constitute a disciplinary offense. Mr. Wu, the Vice Chairman, basically had raised amendment proposals for clauses 4 and 5. And if we accept Clause 4, proposed amendments, and Clause 5 would not be necessary. Is that what you're saying? If 4 is accepted, then Clause 5 amendment would not be necessary. Right. All right. Mr. Kwok, please do continue. Thank you. For Clause 4, 5.5, in response to the ALA suggestion, and in view of the importance of the codes of conduct, to require the PMSA to publish the codes of conduct and the amendments made to them in the Gazette. Views, members? Other aspects of Clause 5, any views, please, apart from the amendment as described by the administration just now? If not, Mr. Kwok, would you please proceed? Yes, the Fifth Amendment pertains to clauses 6, bracket 2, bracket C, and bracket 3, bracket C. And this is in response to the ALA suggestions, and it is to prohibit a person from using a title in any language, both Chinese and English, that so closely resembles registered professional property manager or licensed property management officer, so as to be capable of deceiving or misleading any person to believing that the person is licensed PMP Tier 1 or Tier 2. Now we see for title is the term used in English. In Chinese, it is 名称. 名称 in Chinese is very often used for names of individuals. Perhaps 名号 or 称号 would be more appropriate in the Chinese text. Mr. Kwok, please. This is in addressing the registered professional property manager or licensed property management officer, and therefore we have used this Chinese term, but we can definitely go back and review this and come back again. Yes, Mr. Kwok, a point of supplement concerning 63C, the proposed amendments there in English. There is a typo. It should be licensed property management officer. There is no professional. The word professional is a typo. It shouldn't be there. So you're talking about the English version of the... Yes, indeed. Members, any other views? Concerning Clause 6, other parts of Clause 6, any views, please? Mr. Kwok, can you please proceed? Yes. Thank you, Mr. Chair. Yes. Number 6 and 7, I would like to introduce the two together. They pertain to a new addition, Clause 7.2a, which is to move the original Clause 7.5 to Clause 7.2a. So that is basically just moving of positions. And we would add a Clause 7.2b. There were concerns that professional bodies or officers of the LegCo or district council members might need to obtain a PMC license to provide free advisory services to owners or owners' organizations. And would this fall into the terms of reference of this ordinance? And as we have said before, this should not this kind of work should not fall into the ambit of the ordinance. And in response to the members' concern, we specified that the bill does not prohibit a person from providing advisory services relating to property management services without consideration. And therefore, members' officers of district council, legislative council members' officers do not need to get such a license. Members? But of course, this would be one criterion without payment. That is the advisory service is provided free of charge. That would be one criterion. Is that right? Right. That is advice provided relating to property management services without consideration. So this kind of work would not require a license, and it would not fall into the ambit of this ordinance. The 8th amendment is a technical one pertaining to clauses 7.3 and 4, and this is because of the newly added clauses 7.4a and 4b. This is a corresponding amendment. Members? Yes, I will proceed to explain further, Mr. Chair. Fine. Now, the corresponding technical amendments is for the following amendments, and that is there will be a new clause 7.4a, and this is in response to members' suggestions raised in earlier meetings to specify that if an owners' organization, for example, an owners' corp, decides to switch from engaging a PMC or PMP to self-management, then such decision must be supported by passing a resolution at the general manager of the owners' organization. Otherwise, the PMC and a licensed one will have to be continued. Legal advisor. Thank you, Chair. There are two aspects here that I would like to raise questions on. First of all, in Chinese there, or the termination of the engagement of PMC or PMP, what does it mean? Is it perhaps a termination of an existing contract that is in force at present? Or, alternatively, the PMC or PMP says, well, after 3 months, I will no longer be in service. Then the Owners Corp will go for self-management. Now, is it the former, where the company or where the company is terminated and there will not be any employment of such license organizations? Well, if that is the case, would there be a vote that is in support of the resolution, which will be the minimum requirement? Should it be 50% or 70% at the owners' general meeting? Now, under what circumstances can owners' organization go for self-management? Well, if there is a resolution to cease the employment of the PMC, then it can proceed to do so. That is to say, if there is no resolution at a meeting to cease the employment of the PMC, then the third scenario would apply. It is true that the wording here may perhaps cause confusion or may be misleading. I think we will go back and perhaps review the wording and see whether we can make amendments. Now, when we talk about owners' organizations, we are referring to a variety of organizations, including owners' corporation. Now, for owners' corporation, the number or percentage of votes would already be in the owners' corporations, in the ordinance governing owners' corporations. So we will not specify the percentage here so as to avoid any possible conflicts. Any other questions, legal advisor? Thank you, Chair.
For the shares required, in the case of an owners' corporation, of course, we follow Cap 344. But then if the memorandum is silent on this and we haven't got anything here, then there may be a dispute. That is whether we do it on the basis of the number of shares or the number of owners present. Well, in the case of an owners corporation, of course, will be bound by Cap 344. For the others, it really depends on the kind of organizations involved to check what sort of how many votes will be regarded as a valid resolution. And then that's in relation to Clause 7.4a, legal advisor. Perhaps the administration would like to consider the following. If we haven't got anything to go by, would you say that half of the shares would be the threshold? Mr. Kwok, I'm not sure whether you're aware that probably for the new developments, the case is clear and there is a DMC. But then for older properties, they may not always have a DMC. Of course, we have to meet the requirements concerning the number of flats later in the bill. But at this stage, we are not sure whether it is clearly spelled out in the DMC for each and every building. So I think the legal advisor's concern should be addressed. Thank you, Chair. Yes, we will go back to consider your legal advisor's concern and we'll come back to you next time. Yes, Mr. Wu. Thank you, Mr. Chairman. Can the administration briefly tell me the following? That is, if you talk about different kinds of owners' organizations, what are they? Well, for new developments, of course, basically, we won't be talking about the absence of a DMC. For older buildings, I'm sure they must have passed resolutions covering the property. So I don't think there will be a scenario in which there's never been any resolutions about the property management, and then they start to think about having a resolution with the enactment of this bill, and then they would like to have self-management. So I cannot think of any particular scenarios in which this bill will not cover a particular building. And so you need to have something that would address this sort of exceptional cases. So please enlighten me. Yes, I think this is a valid point. It may not be common, but still we shouldn't overlook the possibility, because after all, we're trying to enact a piece of legislation and it will stay in the law book forever. Mr. Kwok. When it comes to building management, for DMC covered buildings, usually they have owners corporations to carry out the work. For older buildings, in the old days, the DMCs weren't as mature as today. Sometimes they may have mutual aid committees to take care of property management. MECs are not organizations set up under Cap 344, or they don't call themselves a MEC. They may call themselves a owners organization or owners association. So these are the types of organizations that we have come across. Usually, they have something to bind them as to what will constitute a valid resolution. Since the legal advisor has raised this point, we'll go back to check to see whether there is a need to cover such scenarios as well, to fill the gap as well. Mr. Enleong, I did come across a case in which there was this old building with just 8 or 10 units, and then somebody came out and asked for a cleaner to take care of the rubbish collected, but they don't even have a single sheet of paper. You don't have 10 signatures being put down to engage a cleaner to take care of the rubbish of the building. I did come across this case, but I don't know whether the building has already been pulled down or not. Now, Mr. Kwok has said that it would either be CAP 344 and DMC or something like an owners association. I was referring to a case in which there were just a few households. They just casually asked for somebody to take care of the rubbish collected. So in this case, we'll be sort of left with nothing to go by. Mr. Kwok, well, it's sort of the three no's. They don't have any owners organization. Maybe individual owners take the initiative to get somebody to take care of the property management. So they will not be covered by this particular bill because they never had any owners organization to engage a property management company, and no one has got the authority to do this. So there's another problem with property or building management, and it's not covered by this bill. Well, if that is the case, then fine. Other members, any questions? If not, then Mr. Kwok, please continue. Sorry, Mr. Chairman, before we move on, I came from another meeting. I must have sort of missed Mr. Wu Chi-wai's introduction about his CSAs to clauses 4 and 5. I was flipping over the pages and I tried to compare the admin's proposals with that from Mr. Wu. I don't quite understand the objective of Mr. Wu's CSAs. Can Mr. Wu be asked to give us a brief introduction? He has. I can talk to him in private. The paper was only given to us a short while ago, so it's better for us to wait for a written reply from the administration and then we have a more in-depth study, unless you insist. That's fine, Mr. Chairman. I can talk to Mr. Wu after the meeting. I try to compare, and I am not quite clear about the major difference between Mr. Wu's amendments and the administration's CSAs. We have a meeting coming up soon, and that will be on the 16th of November, so you do have the chance to do so. Mr. Kwok would like to add a new clause 7(4)(b). This is to address members' concerns. That is, if we have got a property that contains 1,500 flats or more, then clauses 3 and 4's exemption will not apply. That is, if a property contains 1,500 flats or above, they must have a licensed or registered PMC instead of resorting to self-management. Members, any questions? Regarding the specific number, 1,500 flats, we're talking about flats. Mr. Kwok, can you elaborate on this point? I think at previous meetings, this point was raised. I think we were all concerned about the threshold, whether it should be pitched at 1,500 or whether it should be a larger number. And also you talk about the definition of flat. When you use the term flat, you may talk about a domestic or residential flat. So can you not also talk about it in terms of the shares? Mr. Chairman, first of all, the definition of flat, we propose to follow the definition in Section 2 of CAP 344. It means that any premises mentioned in the DMC, whether we call it flat or not, it doesn't matter. And it doesn't matter whether it is for the purpose of residential, as a factory or as an office. The owner is entitled to have exclusive use of the particular flat vis-a-vis other owners. In other words, other than the public area, any space covered by ownership, by property ownership, it will be regarded as a threat. A car parking space will also be regarded as a threat. So 1,500 flats or more, then it means that self-management would not be permitted. We have already told members that indeed we have got properties self-managed by owners' corporations. When we carried out the consultation, such owners' corporations or owners told us that they would not like to be forced to resort to a property management company. We do respect their aspirations. Some members have also said that in the case of a large property development, if there isn't a property management company, there will be problems with management. So we try to strike a balance, and that's why we have come up with a threshold of 1,500 flats. Now, for those currently self-managed, we tried to look at the number of flats involved, and then the maximum that falls under self-management currently is 1,400 plus. In other words, when we draw a line at 1,500, those that are currently self-managed will not be affected. And then we can also address our concern as to whether those having more than 1,500 flats should be self-managed. Mr. Yip, I think the threshold is about right. In the past, we were worried that if we allow a major residential development to go without a PMC, there will be a problem. You can't leave it to volunteers because under Cap 344, owners corporations are not able to draw a salary. At most, they can get something like a sort of an allowance if you are say the treasurer. So 1,500 flats is about right as a threshold to address our concerns. I think it is appropriate. Yes, of course, we have also talked about the case of properties currently being self-managed, and their performance is satisfactory. In fact, it is quite good. Therefore, we discussed the matter, we considered it, since the performance has been good and there's no need to impose a PMC on them. Mr. Kwok, please continue. Now we come to item 11 in the table, and that's about clause 10. Well, before you go to clause 10, now, for clauses 6 to 10, do you have other questions? If not, then we focus on clause 10. Yes, please. Clause 10. That's about the renewal of the PMC licenses. The original proposal in the bill is as follows. That is, for the license PMC in accordance with 1A, 2 months prior to the expiry, an application should be made to the PMSA. Members were concerned about the timing. That is, if the licensee failed to apply for renewal, whether the application could still be handled. We studied the matter further, and now we have come up with a proposed CSA. I think I have already briefed members at the last meeting, but I can repeat the argument here again. In the case of a PMC, 6 to 9 months before expiry of the deadline, there should be an application for renewal.
Then the person will have to apply 3 months or 6 months before the time to the relevant regulatory body. Now, even if the license cannot be extended before the date, then the license will continue to be effective until the regulatory body can make the decision. So this is the new clause 9. Now, if the application was made after the period, then according to the new Clause 10, the supervisory body or the regulator can may continue to process the application. Sorry, that's actually Clause 12. But of course, there will have to be a reason, a sufficient reason. And if during the period the processing of the application cannot be completed, then there can be a new conditions or fees and to be slapped on. And there will be another 6 months for the processing of the application of the license. If the regulatory body is of the opinion that the license is not to be extended, then within 21 days of making the decision, it will have to notify the applicant and also explain the reason. And we do not want to adversely affect the owners' corporations, and in order to avoid any adverse effect, in particular circumstance and with payment of fee, there will be an extension of the license for not more than 6 months so that the owners' corporation or association can find another property management practitioner or company to take the place. So there will have to be notification to the clients, that is, the owners' corporation which had hired the PMP or PMC, and also there will have to be an explanation as to why there had been a rejection. For example, if there had been if the PMP or PMC is not interested in continuing with the contract, then there should be sufficient notice, and so that there will be time for the owners' corporation or association to look for a new management company. Members, I would like to know of a scenario wherein for certain buildings where they want to change the property management company serving them, is it possible that because of certain issues, for example, at the owners' general meeting, for instance, the newly appointed and the original PMC may not have a seamless handover of work, and what will happen then? And if the property is of over 1,500 flats, what then? Perhaps the more the number of flats, perhaps procedurally at the meeting, or the more it is difficult to control the time of the process of the meeting. Are there considerations for this scenario, please, Mr. Kwok? Yes. Mr. Chair, we would want to provide sufficient time for the owners to find a new property management company, and that is why if the application is not made by the property management company to the regulatory body, then there will have to be sufficient notification to the owners that the license will not be extended for the existing property management company, so the owners will have sufficient time to look for a new one, and the time allowed is 6 months. In the majority of cases, the owners will be able to find a new property management company to take over from the originally appointed one. There may be specific or very particular circumstance where there cannot be handover or proper handover from one company to the next, the new incoming company, but or where the owners will have to go through a period of self-management. We will, in such cases, look at the individual merit of the cases. We will not prosecute the owners just on the basis of that. property management license holders or property management companies is the focus of our discussion. But there are owners who go for self-management, and for property that contains over a certain number of flats, they will have to, that is, the owners will have to appoint a property management licensee. I think we have to remind the owners, corporations or associations of this new development. Otherwise, they would not know of this as a requirement. The government should be cognizant of that. Yes, we will be aware of the situations and cases so as to facilitate a smooth transition. Now, if there are no further questions, we carry on. Clause 10. Yes, this is a proposed amendment that we have not adopted. Clause 10(2). In the previous meetings, a member had asked the wording of must not renew a license unless, the 10(2) says there. And the argument was that there must be certain discretion given to the authority. Now, after studying the text, there are three criteria after having satisfied which can there be a renewal of license. One, that the applicant is a suitable person to hold the license and the applicant meets all the prescribed criteria for holding the license, and that the applicant has paid the prescribed fee for the issue of the renewed license. These are the three criteria. If the applicant cannot even satisfy these three criteria, then the authority should not renew the person's license. And therefore, we use the word must. Any questions, members, concerning this? Now, in particular, for the amendment of the ordinance, we have advanced the time for application, and also we have considered for those applicants who have come late, that is, submitted their application after the period. We have also taken that into account. Now, for those who have submitted their application late and the regulator accepts the application and the regulator needs time to review the application, it may actually extend the period for over 6 months, and certain fees will have to be payable. Now, for the licensee and or the company or the individual should, of course, follow the time for renewal of license. For those who did not follow the time period, of course, it would affect the entity or the individual itself. But what about other parties? That is to say, apart from extending over 6 months, and there are fees collectible or payable given that, what I mean is I do not want the regulator to be under pressure because the applicants are late and tardy with their application. I'm asking how we can enforce it so that people will comply with the application period. Now, if the specified period had elapsed before the application is made, then there will be a surcharge for the application fee so as to present an incentive for timely submission of the application. This will ensure that the owners will not be adversely and unnecessarily affected. Yes, we will do so. Continue, please, Mr. Kwok. Clause 12. The proposed amendment is for 11(2)(a)(2), B3 and C4, and 4(a)(2) and B3 undergo textual amendment. This is because of the ALA suggestion in the Chinese version to add 協議 after 重整 in the Chinese text to ensure consistency in the Chinese expression. Members? Legal advisor, please. Thank you. Mr. Kwok, please proceed. Yes. The 13th amendment that we propose pertains to clauses 13.2h and HA. And HA is a new addition, and this is in response to members' suggestion at this meeting to specify that Section 2 of the Rehabilitation of Offenders Ordinance Cap 297 would only apply to PMCs that are natural persons and not to PMCs which are companies. Members, any views, please? If not, Mr. Kwok. The 14th amendment proposal pertains to clause 13(7), and again this is in response to the ALA's suggestion to change in the Chinese text to ensure consistency, and that is to change 登記冊及 to 登記冊或. And this is in view of the amendment to clause 13(2) to make the corresponding amendment. Members, any questions or opinions, please? If not, Mr. Kwok, please proceed. Yes, thank you, Chair. The 15th provision to be amended is clause 13(7) and 8. This is to protect the privacy of PMCs that are individuals and PMPs. Their conviction records should be less accessible than PMCs that are not individuals, and this is in response to members' suggestion. And we would want to specify that the conviction records of PMCs that are not individuals would not be available on the Internet, and that no person would be allowed to obtain copy of the conviction records of PMCs that are individuals and PMPs from the register. Members, any views, please? If there are none, Mr. Kwok, would you please proceed? Yes. The 16th provision to be amended is found in clause 15(1). And when we were discussing clause 10, we had already mentioned that there will be certain fees made payable where the PMC's license is to be extended. And this is exactly it for license renewal applications made after the stipulated time frame, and for those PMCs whose license renewal applications are rejected, to empower the PMSA to prescribe by regulation that fees may be charged for extending the validity of the license. Now, for tardy submission of application, we can also consider levying a more hefty fee. You have mentioned that. This is, of course, about lengthening the validity of the license in terms of time frame. How does it tie in with that? Now, for the extension of the license, actually it is in 15(1)(b) and D. That is to say, the PMSA can directly prescribe by regulation these fees. And so these relevant fees will be prescribed in that manner. If there are no questions from members, Mr. Kwok, would you please proceed? Yes.
For our 17th CSA, you find it in clause 16(1)(a). That's about the definition of client. In response to members' suggestion, we'd like to clearly define the term client. Our suggestion is that client means the owner's organization of the property, and the owners of the property could pay or are liable to pay the management expenses in respect of these services. Thank you. Yes, please continue. The 18th item, Also on clause 16.1, it is our policy intent that a licensed PMC should provide the PMC's clients in the property for which the PMC provides property management services with the prescribed information relating to the property in the prescribed manner. Our amendment will clarify our legislative intent. So for clause 16.1, we have split it into 16.1 and 16.1a. Yes, please continue. The 19th CSA, that's in relation to clauses 16.2, 2a and 4. Our intention is that certain prescribed information, like the draft budget, the budget as well as the revised budget, such information should be sent to the owner's organization and/or be displayed in a prominent place in the property, while other prescribed information, like the books or records of accounts, income and expenditure account, and balance sheet, should be available for inspection by the clients. So we'd like to amend the clause so that for different prescribed information, a different dissemination manner can be prescribed. Members, any questions or comments? Mr. Kwok, please carry on. Item 20, that's about clause 16.3. We'd like to clarify that property management services are provided by the PMC to the property and not the clients. This is to address the concern of the PMC as to whom the information should be provided. Yes, please continue. Thank you, Mr. Chairman. Item 21. That's about clause 21.5. Sorry, Mr. Kwok. Let me check with members. We have just covered clause 16.3. As far as I can recall, for the other amendments, I don't think members raised any particular points. So, if you haven't got other questions, I will ask Mr. Kwok to continue with clause 21. Mr. Kwok, yes, clause 21.5. The clause as presently drafted did not empower the PMSA to require electronically stored information or document to be reduced into a written form on paper. In response to your ALA's suggestion, we would like to revise the clause so as to empower the PMSA to require electronically stored information or document to be reduced into a written form on paper. Thank you, Mr. Chairman. Yes, carry on. Item 22. Clause 21.6a. In response to the ALA's suggestion, we would like to include a reference to an officer of a corporate in the clause so as to cover the scenario that the person required to provide information is a company. Yes. For clause 21, members, any questions or comments? If not, Mr. Kwok, please continue. I think the next one is about clause 24, right? So for clauses 22 and 23, Members, any comments, please? If not, then we continue with clause 24. Mr. Kwok. Thank you, Mr. Chairman. Item 23 is about clause 24. In response to the legal advisor's suggestion to empower the PMSA to receive or consider any material, whether by way of oral evidence, written statements, documents, or otherwise, and whether or not the material would be admissible in civil or criminal proceedings, in order to align the power to be conferred on an appeal tribunal. So the appeal panel and the appeal tribunal will have their powers aligned. All right, members, if you do not have further questions, Mr. Kwok, please continue. Thank you, Mr. Chairman. Clause 24.4 is the next CSA. In response to members' suggestion, we would like to specify that any party to a hearing before the PMSA might request the hearing or any part of the hearing to be held in private, and it was for the PMSA to decide whether such a request should be acceded to after consulting the parties concerned. I think this is a very simple one. Members, if you do not have other questions, then I will invite Mr. Kwok to continue. Thank you, Mr. Chairman. Item 25, it is a textual amendment, and the simulation to clause 25.1b. In response to ALA's suggestion, for the English text, fine would be changed to penalty for the sake of clarity. All right, please continue. Item 26, that's about clause 25.5. In response to ALA's suggestion, we propose that for the orders of the PMSA or disciplinary committee, even if there is an application made to revoke, vary, or suspend the order should take effect first. Thank you. Mr. Kwok. Members, any comments or questions? If not, let's continue with the CSAs from the administration. The next one will be clause 31. So for clauses before clause 31, do you have other comments to make? If not, then Mr. Kwok, please continue. Mr. Kwok. Mr. Chairman, if I may add a word here. In our paper, we've mentioned that for a number of clauses like 21 to 24, we are not proposing any amendments. At first, we said that in relation to documents, we should also include electronic documents or electronically stored documents. For clause 21, we have already proposed an amendment so that electronically stored information document can be required to be reduced into a written form on paper. And for clause 24, since such an approach can be invoked, and therefore clause 25 can already cover the need, that is to cover documents that are electronically stored. Therefore, for clause 24, we don't need to amend it further to define what's meant by document and whether it covers electronic documents as well. So it will be related to clause 31 as well, and in a moment I'm going to talk about that as well. Thank you, Mr. Kwok. Item 27, that's about clause 31.4. That's about self-incrimination. In response to members' suggestion, for clauses 31.4b and c, they will not be sort of repeated, And so 31(4)(c) will be deleted. Mr. Chairman, if members do not have questions, can I move on to other possible amendments to Clause 31? For Clause 31, that's about self-incrimination. At earlier meetings of the Bills Committee, both members and the ALA did raise this point, that is whether it will apply to the disciplinary hearings as well as the appeals. We're now in the process of studying the matter further with the DOJ. Later on, we'll come back to you to give an account as to whether this provision should apply to other scenarios, like when the appeal boards are hearing the cases. We'll come back to you later. Members, any questions? Legal advisor, anything? Yes, other members? No? Once you have come to a view, please notify us ASAP and give us a paper so that we can study your decision. Mr. Kwok. Mr. Chairman, the next one is about Clause 36. Yes. Item 28. Clause 36(1)(d). Well, again, this is to respond to members' suggestion to make the clause clear, readable, and also more easily understood. So we have come up with a textual amendment. We are not changing the meaning of the clause. Thank you, Mr. Chairman. All right. Members, if there are no questions or comments, Mr. Kwok, you may want to continue. Yes, thank you, Mr. Chairman. Item 29, that's about Clause 36(3). I think this is similar to an earlier clause in relation to hearings. That is, if any party to a hearing before the tribunal would like to have the hearing or any part of the hearing to be held in private, then after consulting the parties concerned, the chairperson of the appeal tribunal can decide whether such a request should be acceded to, and this is similar to an earlier clause, that is Clause 24.
The 30th item for amendment is found in Clause 37(1), and this is a response to member suggestion. And the purpose is to make it clear that the appeal tribunal has the power to make an order for costs and expenses incurred in relation to the hearings before it. The legal advisor, please. Yes, for costs and expenses, that would be costs incurred in relation to hearings before the tribunal. But what about disciplinary hearings, that is in the early stage of the proceedings? What about costs and expenses there from? Mr. Kwok, can you please clarify, legal advisor? You are talking about, yes, the disciplinary hearing. That is Clause 23. What if there are also legal costs and expenses incurred? Can that also be dealt with during the appeal tribunal hearing? Yes. Costs and expenses incurred in relation to hearings. Now, if I understand correctly, according to 25(2), at the point of hearing, where there are costs and expenses incurred, and the order thereof, You're talking about disciplinary hearing. You're asking whether the costs and expenses incurred can be dealt with at the appeal stage. Thank you. If you look at 33, the original 33, specifically clause 33E, according to an order made under section 24(7) or 25(1) or 2 by authority or the disciplinary committee. So that is to say this can be done. Any other views, members, or questions, please? If not, Mr. Kwok will continue. Yes. The 31st provision to be amended relates to clause 39A. This is a new provision in response to members and the legal advisor's suggestion to make a party, witness, counsel, solicitors, or any other person who appears before an appeal tribunal will also be protected by the same privileges and immunities as that person would have if the appeal were civil proceedings in the court of first instance. Thank you. Any opinions or questions, please? There being none, Mr. Kwok, please continue. Thank you, Mr. Chair. The 32nd provision to be amendment goes to the schedule, and the heading of Schedule 2 in response to the legal advisor's suggestion to change fine to penalty in the English text for the sake of clarity. So, before Schedule 2, for any stipulations or for Schedule 1 members, do you have any other views or questions, please? Schedule 1, of course, during discussion, there were related members or sectors related. There is listed 7 services concerning, for instance, Stipulation 1 for the property general management, because we know that for this kind of single there need not be any license for single service. What is this single service? What does it mean? Mr. Kwok, can you please explain to us? According to Schedule 1, as it stands here, there are 7 services that we have segregated in terms of property services and management. And they are according to according to the qualifications structure, the 7 sectors that are mapped out, and they pertain to management of the environment, repair, maintenance, improvement of property, finance, asset management relating to a property, general management services, facility management relating to a property, and human resources management relating to personnel involved in the management of a property. And lastly, the seventh service would be legal services relating to the management of a property. Now, for these 7 major categories of services, what do they include in terms of professions? There is a description here. And in the future, according to this blueprint, there will be a study of what professions come under the categories. Now, where there is but one category of service provided, then no license is necessary. But where there is more than one category of service provided, then there will have to be a license, that is a property management company license applied for. So for these companies, they will providing more than one category of service, they will have to make the application for such license. We do want to avoid unnecessary hindrances, and we also want to avoid the companies which want to shirk from this legislation in providing different categories of service. Well, I think we all want this to be clear. On the one hand, we do not want there to be any contravention of the law where the company provides not a single category of service, or where the property management service after time progresses had changed. For instance, for property management in the past 20, 30 years, the development had been significant. And the nature of service is getting broader and broader. And the industry and the relevant property management personnel, I'm sure we would want it to be there to be some clarity for them. We do not want there to be unnecessary application for licenses, of course, causing wastage and administrative burden. But at the same time, as Mr. Kwok had mentioned, we do not want there to be any avoidance of regulation by any party out there. And there will have to be a clear demarcation as to what merits licensing and what does not require licensing. I think after the PSA had been set up, there will be a clear listing and detailed listing. But I know parties within the industry want this to be as early as possible, made clear as early as possible, so that they know where they stand in terms of having to or not having to apply for license. Mr. Kwok, can you pay attention to this point? Yes, indeed, and we know very well the concerns of the industry. They would want this to be clarified as early as possible, and therefore in the January document we have the services that may come under these major categories. We have tried to list them out. And the document will serve as a framework in the future for the drafting of the subsidiary legislation. And there will be further specification and clarity in the subsidiary legislation, of course. And in the meantime, we will keep in close liaison with the industry. Where they are unclear, we'll be very happy to continue with the discussion and communication with them. Now, concerning the subsidiary legislation, if I may point out again that the subsidiary legislation will go through negative vetting. Is that true? Yes. It is correct, Mr. Chair. Yes, there is a time limit to that, and we may be concerned about that. During the discussion, I remember the government had also committed to the timing. That is to say, there will be sufficient time provided to the relevant committee. And the information relevant would also be made available early to the members for study. And I would want to urge the government in living up to that. Mr. Chair, yes, indeed. The subsidiary legislation will be the work of the newly set up authority. When the subsidiary legislation comes to the before it comes to the LegCo, the relevant committee will be informed of the detailed content of the subsidiary legislation. And as mentioned just now, we will keep in close communication with the industry to clarify any areas that they feel are unclear concerning the drafting and the categories of service. Yes, if there are no opinions, we go to Schedule 3. Is that true? Mr. Kwok. Thank you, Mr. Chair. The next provision to be amended is the 33rd one pertaining to Schedule 3, Section 3. In response to members' suggestion in the Chinese text, the term "santao" to change 草金 to 山草 in the Chinese text. Thank you. The 34th provision to be amended is in Schedule 3, Section 6. The original stipulation was that the chairman of the PMSA, where he is out of town, the vice chair will take up the work. And members have opined that because of technology, the chairman may actually be able to, through telephone, video conferencing, or other electronic means, perform the functions of the office. And therefore, in response to members' suggestion, it is to empower the chairperson of the PMSA to determine, having regard to the specific circumstances, whether it is necessary to designate the vice chair to act in his place when he is temporarily outside of Hong Kong. Yes, we continue, Mr. Kwok. Item 35 for amendment pertains to Schedule 3, Section 9. And this is in response to the Assistant Legal Advisor's suggestion to ensure that the confidentiality of the PMSA's meetings would not be compromised as a result of individual members participating by electronic means. And we have made the relevant amendment to this effect. Any views, questions, members? None? We continue. Mr. Kwok. The 36th proposed amendment is Schedule 3, Section 13, and in response to the Assistant Legal Advisor's suggestion to provide that the resolution may be in the form of one or more documents, each in the same form and signed by one or more members of the PMSA in order to cater for the scenario that each member assenting to the proposed resolution signs their own copy. Thank you.
Mr. Kwok, you may continue. It is again about Section 13 of Schedule 3. In response to the legal advisor's suggestion, the clause as presently drafted could not cater for the scenario where a member requested a meeting after a written resolution was assented to. So we would like to revise this clause. That is, a written resolution assented to would become void if a meeting is subsequently requested. Legal advisor. Thank you, Mr. Chairman. if there is a request for a meeting, then the written resolution will be void. But then the subsection 4 says that you need to raise the request within 14 days. So please clarify whether there is a need to do so in 14 days, Mr. Kwok. I think I need to talk to the law draftsman to see whether there is a need to clarify it. All right. Other members, do you have any questions or comments? If there isn't, then Mr. Kwok, please continue. Item 38. This is about Section 19(1) of Schedule 3. That is a textual amendment in response to legal advice's suggestion for the Chinese text. Some should be changed to 審計 so as to tally the Chinese translation of the term audit. Mr. Kwok. Item 39. That's about Section 22 of Schedule 3. The clause as presently drafted does not require the annual report to contain an outline of the disciplinary hearings. And at your meetings, both members and your ALA have made comments, and we're now requiring the annual report to contain an outline of all disciplinary hearings conducted under Clause 23. Thank you. Mr. Alan Leong. Mr. Chairman, I recall that when there was a discussion on this point, we wondered whether there is a provision to allow us to learn from experience. So when you talk about having an outline, how brief will it be? Can you give us an idea? Are we going to mention the building involved, the parties to the hearing, and the date of the hearing, and that's it? Then it won't be meaningful. I think we want to know about the nature of the case. Say the specific clause or specific provision under Cap 344 or certain provisions in the DMC, and we want to know about the arguments put forward by both parties. And then we want to know about the ruling regarding the arguments put forward. I think we want them as well. If you talk about an outline can be very brief, so brief that it contains little substance. Mr. Kwok, yes, we are aware of Mr. Leung's concern. When we talk about an outline, of course, we aren't talking about the mere facts only. Say a hearing has been held and then the parties to the hearing. No, we want to have more than that, with the purpose of enhancing the awareness of the industry and enabling the public to understand the questions of disagreement. Of course, we hope that when it refers to an outline, we'll have the major elements in the case presented, say the point of contention, the determination, and the justifications for that determination. So the outline is supposed to have such details as well. But I don't think we need to spell out the details here. And I don't think it is right to have an exhaustive list here. But this is indeed our legislative intent. Legal advisor, please do this for us. Please look at the other legislation, like the Inland Revenue Appeal Board. Under that piece of legislation, a record is also required. I want to know whether the ordinance would spell out the details needed for the outline of the hearings in the annual report. If you can give me an answer, so it will be good. If not, please check it for us if you don't recall off the cuff. Yes, Mr. Kwok, for the hearings, we will be interested in the relevant clauses as well as the decisions made. It will be of high reference value. It will also facilitate the industry in having a proper understanding of the requirements, and then they can follow suit. I'm sure everybody will be interested in having such a useful source of information and know about the outcome of the hearings. I think there was some discussion here, and we hope that this can be achieved. Legal advisor, please also check similar provisions elsewhere in the law book, so that we can be sure that we are reflecting the intent clearly and that the revision can achieve the purpose. So, Mr. Kwok, please provide the information to us. Please find a way to address Mr. Alan Leung's concern. Sure, Mr. Chairman, we will do more homework here. Let's continue, Mr. Kwok. Thank you, Mr. Chairman. Item 40, that's about Section 22(3) of Schedule 3. As it is presently drafted, it does not require the Director of Audit's report be laid on the table of the LegCo, and it does not specify who is to cause the report to be so tabled. In response to the Bills Committee's suggestion and your ALA's suggestion, we would like to revise the clause to say that the Director of Audit's report is to be laid on the table of the LegCo, and the President of the LegCo will cause the report to be tabled. Thank you. Legal advisor. Thank you, Mr. Chairman. Now, your CSA says that it will be given to the President of the LegCo, and then it will be laid on the table of the LegCo. Can you not simplify it? Can you not ask the Director of Audit to table it on the to have it laid on the table of the LegCo? Because the Director of Audit has been empowered to lay the report on the table of the LegCo. Anything to add? I think either way can do. Mr. Chairman, yes, Mr. Kwok, as the Lord Draftsman has said, either way has been done, so we'll try to make reference to the drafting of similar legislation, and then we'll come back to you on this point. For the first 3 sessions in a term, we'll get 2 reports from the Director of Audit. For the final year, we get 1. I think the report is tabled in accordance with the relevant ordinance. So how come that you need to have a specific provision here? That is Section 22(3). Mr. Kwok, or anybody else that can answer Mr. Alan Leung's question? Thank you, Mr. Chairman. My understanding is that this PMSA is not a government department, so the case may be different, but I think I need to look into the matter further. Yes, for government departments, Mr. Chairman, I'm sure you have learned a lot about that. So in the case of the Civil Aviation Department, we don't need an empowering provision. So probably in this case, it is not a government organization. Yes, for non-government organizations, we have got a similar provision in the governing ordinance. I think the practice is different. So I'll urge the administration to look into it further to find out which is the better route. That is, have it laid on the table directly, or whether have it given to the president of the LegCo first. If there aren't other questions, let's continue. Mr. Kwok. Item 41. Schedule 3, Section 23(1). Again, this is a textual amendment to respond to the ALA's suggestion in the Chinese section. Wai Gei will be changed to Gei to avoid inconsistency. All right, thank you. Please continue. Item 42. That's about Section 23(9) of Schedule 3. In response to members and ALA suggestion, and for the avoidance of doubt, we want to specify that the committees under the PMSA shall be subjected to Clause 46(9) of the bill, and that's about the declaration of interests. All right. If members do not have any views, then I will ask Mr. Kwok to continue. Item 43. And that's about Section 3(1) of Schedule 4. Again, this is a textual amendment. In response to members' suggestion, for the sake of clarity, we want to specify that the term "a person" refers to an applicant for a provisional PMP license. Thank you, Mr. Chairman. Thank you. Mr. Kwok, please continue. Item 44. Please turn to Schedule 4, Section 3A. This is a new section. This is to respond to members and ALA's suggestion to specify that clauses 12 and 13, the PMSA's disciplinary powers under Part 5, the appeal mechanism under Part 6, and the defense under Clause 61 shall apply to the holders of provisional PMP licenses, and to move the original Section 27 of the Schedule 4 to Clause 3A of the same schedule for sake of clarity. Thank you, Mr. Chairman. Thank you. Mr. Kwok. Mr. Chairman, item 45, that's about Schedule 4, Section 41A. It is a simple textual amendment. And in response to ALA's suggestion, in the Chinese text, 生ting 话 will be changed to 话. In other words, taking out the two characters 生ting. Thank you, Mr. Chairman. All right, Mr. Kwok, for the other clauses, do you have anything to add? Thank you, Mr. Chairman. I think I have covered all the draft CSAs that we have included in our papers. Of course, there's still one point outstanding. That's in relation to self-incrimination. We're still liaising with the DFJ. If there is to be a CSA, we'll come back to you ASAP.
Yeah. Members, for the proposed amendments brought by the administration, we have already discussed them. Now, concerning this bill, do you have any other suggestions, opinions, or questions, please? If there are none, then I would hope that the government would, on the basis of the discussions today at the meeting, and for what Mr. Kwok had mentioned, that necessitate seeking of opinion, asking other parties to provide a written response before the next meeting. And at the beginning of the meeting, Mr. Wu Chi-wai, the Vice Chair of the committee, had submitted certain documents and suggestions. And I would hope that Mr. Kwok and the departments would provide your response to that. For the Schedule 3, there is a supplement to be made. Yes, Mr. Lam. Yes, the legal advisor talked about the new 13(5), whether in Clause 4 that it will have to be submitted within the 14 days. Well, actually, I believe that would not be necessary, because if the submission is to be made to the PMSA, and if that is a time when the papers were being circulated, the decision had not been made yet. And bracket 4 talks about the decision being made 14 days within the time of the decision made. And that will no longer be applicable as in bracket 3, because in bracket 3, the decision had not been made yet. And if the decision had been made, then the application will have to be done in 14 days. Legal advisor, do you have any follow-up on that? Thank you, Chair. No, I do not have any further follow-up. Yes, I accept it. Very good. If there are no other opinions or questions, then we close the meeting here. As mentioned just now, before the next meeting, we would very much like to have the administration's written response. And we have mentioned the next meeting, date being 16th of November, 4:30. Room 2A. This is a room. We will thank you very much for coming to the meeting.